नमस्कार। आपका आपके YouTube चैनल कानूनी चर्चा में व्यूअर्स, यू आर वेलकम इन योर ओन चैनल कानूनी चर्चा। जैसे आपको ये जानकारी है कि मैं लॉ सीरीज हमने डिफरेंट टॉपिक्स पे बातें करते हैं, जब कानूनी चर्चा करते हैं, तो उसी कड़ी को आगे बढ़ाते हुए मैं आज जो संविधान हमारा कॉन्स्टिट्यूशन ऑफ इंडिया है उस पे बात करूंगा, उसके फंडामेंटल राइट्स में। तो जैसे आप जानते हैं कि फंडामेंटल राइट्स ये जो हमारे कॉन्स्टिट्यूशन में है, संविधान में है, ये आर्टिकल 12 से शुरू होते हैं और 35 तक ये हैं। 12 इंक्लूसिव है और 35 भी इंक्लूसिव है। तो एक गोल्डन ट्रायंगल जो फंडामेंटल राइट्स के निस्बत है, 3 जो आर्टिकल हैं कॉन्स्टिट्यूशन में, उनकी बड़ी महत्व है, बड़े इंपॉर्टेंट है। वो गोल्डन ट्रायंगल उनको कहा गया है कॉन्स्टिट्यूशन का। वो है आर्टिकल 14, आर्टिकल 19 और आर्टिकल 21। तो आज मैं बात करूंगा इन गोल्डन ट्रायंगल के आर्टिकल 21 में। जो उस पे बात होगी, उसका जो मैं केस लॉ भी साथ साथ रेफर करता जाऊंगा, ताकि जो हमारे विद्यार्थी हैं, स्टूडेंट्स हैं, लॉ स्टूडेंट्स हैं, लॉयर्स हैं, जजेस हैं और जो यूनिवर्सिटी में टीचर्स हैं, जो भी लोग लीगल फर्टेनिटी से जुड़े हैं, और मैं ऐसा सिंप्लीफाई कर दूंगा जो आगे भी करता हूं और आज के वीडियो को, ताकि ये सभी लोगों को, आम लोगों को भी ये समझ आ जाएगी आज की बात जो इस आर्टिकल 21। तो आर्टिकल 21 ये देता है प्रोटेक्शन। मैं आपको थोड़ा सा इसमें बता दूंगा। इसमें है द राइट टू प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी। तो इसमें क्या है, ये 2 लाइंस का ये आर्टिकल है, लेकिन ये जो सुप्रीम कोर्ट ऑफ इंडिया ने फ्रॉम टाइम टू टाइम इसकी एक्सपेंशन की है बाय डिलीवरिंग डिफरेंट जजमेंट। तो इसको इतना ब्रॉड कर दिया है। तो इसको इसमें मेन चीज है, 3 चीजें इसमें मेन आ जाएंगी, लाइफ और पर्सनल लिबर्टी। पर्सनल लिबर्टी को प्रोटेक्ट करना है, ये भी गारंटी देता है कॉन्स्टिट्यूशन हमारा, और ये लाइफ को भी। और लाइफ कैसे होनी चाहिए, ये भी एक बात है। और इसमें अगर ये दोनों चीजों से डिप्राइव करना है किसी ह्यूमन बीइंग को, ह्यूमन बीइंग मैंने ये कह दूं, सिटीजन भी हो सकता है, नॉन सिटीजन ऑफ इंडिया भी हो सकता है। ये आर्टिकल टू एवरीबॉडी कैन अवेयर दिस आर्टिकल हु इज इन इंडिया। he may be citizen, he may be non-citizen. So then he may be a male, he may be from any gender. Now there is also a third gender recognized by law courts. Then this article is applicable to all. I will start from the judgment of A.K. Gopalan. What happened in judgment of A.K. Gopalan? He was a communist leader, political leader, communist leader. He was detained under Prevention of Detention Act. Then he approached the Supreme Court of India for his release. It may be by habeas corpus writ at that time. Or it may be by Article 32 of the Constitution Act. We are concerned with what was the ratio decidendi of that judgment. What happened? The law courts, this Supreme Court of India, our highest court of India, apex court of country, has given a hearing on the regarding detention of the communist leader A.K. Gopalan. After he, what was a narrow opinion taken, legal opinion, this article of the Constitution was interpreted in very narrow manner, you can say, very not broad view was given by the Honorable Supreme Court of India. No doubt afterwards Supreme Court of India this given broad view and overruled this judgment. Then I will go about that. Court has said that whatsoever procedure is mentioned in the Prevention of Detention Act, that has been followed by the detaining authority. So there was a argument from the petition side that the procedure provided in Prevention of Detention Act is not fair, not transparent, or it is not in accordance with principle of natural justice. Simultaneously, it was also said that due process of law, this due process of law are under Common Law Act. Or this due process of law, principle of natural justice, should be in conformity with constitutional provisions, particularly Article 21. But Supreme Court of India at that time did not agree with the arguments, the contention put forth by the petitioner's lawyer, whosoever appeared at that time, and held the detaining authority has detained in accordance with the procedure provided under Detention Act. Afterwards, the many cases come. Main case where evolution of this interpretation of procedure established by law has come in 1978 in Maneka Gandhi case versus Union of India. You might be knowing, she was a political leader. She was about to go abroad. Her passport was impounded by the passport authority. She approached the Honorable High Court, the Supreme Court of India, apex court of the country, and at that time, she argued, or her counsel argued before the Honorable Supreme Court of India that she has a fundamental right to travel abroad. That is provided by Article 19 of the Constitution. Simultaneously, it was argued that Article 21 provides right to life and personal liberty. This right to travel should be also included in personal liberty, and it is to be supplemented by Article 19 of the Constitution. The simultaneous both are. So, then it was also contention before the Supreme Court of India that the passport authority has not followed the procedure in a fair, transparent and open manner. Principle of natural justice was violated. She was not given prior notice, prior hearing before impounding of her passport by the passport authority. Then law evolved. Supreme Court has taken a broad view, expanded the interpretation of Article 21, particularly vis-a-vis procedure established by law. It was that principle of natural justice is a prime consideration, or others, this fundamental rights also should be interpreted in the light of principle of natural justice. No opportunity of being heard was given to her prior to impounding her passport. In Maneka Gandhi's case, A.K. Gopalan's view taken in A.K. Gopalan's was held not a good view, not in accordance with procedure and due process of concept of due process as available in US, American Code, Constitution, and accordingly the American Constitution follow the due process of law. It is a common principle And they say common law principle of justice. This is happened now. Now, with different judgments comes afterwards. After 1708, different this RT was expanded in such a its spheres of the what is life. It is right of education, right of privacy, a right to have free environment, pollution free environment, and pollution free air. It is also included, considered as part of a human life, a dignified life of a life of a life of a human being under Article 21. I may refer here some this judgments and in very judgments, and simultaneously what is included. I have referred here. This is right to health, self-respect, right to livelihood. This accordingly Article this right to work. There is a Maneka, महात्मा गांधी जो रूलर नेशनल रूलर स्कीम जो है 100 डेज जो हम वर्क देते हैं एक पंचायत में, जो भी उसी की कॉन्स्टिट्यूशन. राइट टू एजुकेशन अप टू 6 to 14 years students, children. It is also included as a fundamental right. Now, right to life. Right to life, there was earlier a decision in the case, this the right to die. It was also claimed at some time. But it was not allowed. Article, this section 309 of IPC was asked that it should be declared unconstitutional. But in a judgment, it was only declared unconstitutional. But afterwards, it was declared constitutional. My concern is, however, right to die with dignity has been included in Article 21 of the Constitution. Is considered as a part of. So it was held by the Honorable Supreme Court of India that right to life includes right to die with dignity. This is a Gyancore versus State of Punjab. There is a P. Ratnam versus Union of India. It was allowed. You might be knowing that if some patient is in anesthesia, in vegetative state, then he make a prayer before Supreme Court of India, and there are many cases. I have referred these cases. These are also related to that. One has claimed that he be allowed to die because he is not he is a vegetative death. He is not functioning. His organs are not working. So then there was a Supreme Court has that said that there is a 2 types of active death and passive death. So passive death in particular case, by invoking Article 142 Constitution of India and giving benefit of Article 21 of the fundamental rights, then Constitution of India, then the right to die with the dignity is allowed in particular cases, special cases, after getting a medical opinion of the concerned hospital where he is hospitalized. Then after that, so he is allowed to die passively. So then right to die with dignity is also included in this Article 21. So then many this article virtually has been expanded. Its applicability has been expanded in right to privacy, right to fair trial, right to speedy trial, right to electricity, right to movement, all right to privacy. Aadhaar Act, you might be knowing it in a Pottaswamy case. In K. Pottaswamy's case, KS Pottaswamy case, you might be know Aadhaar Act was said, and it was act that it is constitutional, but its certain provisions was directed to be removed from the Aadhaar Act. So then I am today concerned with that I am Article 21. I have confined myself in this today's Kanooni Charcha discourse that Article 21 is a very important right. It relates to, I am now making it very summarizes my whole the earlier discussions. It relates to right to have dignified life, human life, and if somebody violates, state violates, or anybody else violates, then the Supreme Court can intervene and protects the life and personal liberty of a human being. Procedure established by law, its interpretation has been changed by the Honorable Supreme Court of India. It should be fair, not arbitrary. It should be transparent, based on principle of natural justice. So my due process of law available in American Constitution, US Constitution, that has followed, that has adopted in by Indian courts also, Supreme Court of India also. Then this is today's lecture. Then my I have referred golden triangle. I have referred 3 articles. 14. Then in next episode, I will talk about Article 14, and thereafter I will also talk about Article 19 of the Constitution, so that this golden triangle available in the Constitution of India in fundamental rights 14, 19 and 21 would be completed. Thank you very much. थैंक यू जे मेरा मैंने बड़ा सिंपलीफाइड तरीके से जे आर्टिकल 21 पे बात की, तो मेरा यही है जे जो मेरा चैनल है इसको सब्सक्राइब करें, इसको शेयर करें लोगों में जो मैंने बात की आज, और इसको लाइक करें, और ताकि ये जो कानूनी चर्चा मैं सीरीज चला रहा हूँ, लास्ट सीरीज चला रहा हूँ, ये हर आदमी से आम आदमी तक, लास्ट आदमी तक पहुंचे, और उसकी भाषा में जो लोग इसको थोड़े समझदार हैं, जो मेरी बात को समझते हैं, चाहे लॉ ग्रेजुएट हैं, लॉयर्स हैं, जजेस हैं, तो उनको मैं एक रिक्वेस्ट करूंगा, जहाँ हमारे जो लॉ स्टूडेंट्स हैं, लीगल सर्विस अथॉरिटी है, जहाँ और भी लोग हैं, तो इसको थोड़ा सा अपने तरफ से और मेरे जो है लोगों को इनका मीनिंग, आम आदमी को इसका मीनिंग वेरी सिंप्लीफाइड तरीके से समझाएं। थैंक यू वेरी मच, ताकि लोग ज़्यादा से ज़्यादा अपने हक के लिए और खासकर फंडामेंटल राइट्स के लिए जागृत हों, जागरूक हों, और अपनी कानून की जो भी उनको रिक्वायरमेंट है, जो आप अप्रोच कर सकते हैं, और आप कानून की जानकारी होना सबसे बड़ी जानकारी है। तो यही कहते हुए शब्दों से मैं नेक्स्ट एपिसोड के लिए आपसे विदा चाहता हूँ। थैंक यू वेरी मच। थैंक यू दोस्तों।